of the ban of the volume 1 or volume A. Where we talk about the context. And I want to preface this by saying that everything I'm going to say here is not disputed. The only thing that's disputed, which is not important in what I'm going to say, is that the Zondo Commission did not produce any tangible results. Otherwise, all this is effectively a common cause. This is what it says in the affidavit of Dr. Hlophe. If true, these allegations, which include the judiciary for the first time, represent unprecedented levels of real state capture. They exceed by far anything which was previously dealt with in the so-called Zondo Commission on State Capture. That context is crucial in this application. And then he says in the next paragraph, the so-called Zondo Commission, which was dealing with narrower issues, lasted for approximately 4 years. And cost the taxpayer an estimated 1 to 2 billion rand with no tangible benefits. And that's so we can write that off because that's disputed. We'll deal with it later. I'm just doing the introduction. The last sentence is very important. We say, it is largely responsible for the present public fatigue and skepticism about commissions of inquiry and their utility. And I want to start there for a reason. So we all agree that this proposed commission is going to deal with wider issues than the Zondo Commission on State Capture, in the sense explained there. We all agree that that commission lasted for 4 years and cost the taxpayer between 1 and 2 billion. And one can extrapolate that this one will cost at least that or more. And we also all agree that the public is tired or sick and tired of commissions of inquiry and their utility and skeptical about their utility. The reason I'm starting there is because this is the backdrop against which the decisions, the impugned decisions, have been taken. The purported reason, actually the only reason given in the announcement made by the President for placing Minister Mchunu on leave, was to make the commission to be more effective, or words to that effect. I'll come to that in detail right now. And a generous interpretation of the leave of absence decision would be that, because we asked the rhetorical question, leave of absence pending what? And supposedly the most generous answer that one could give is that it's pending the commission. So the commission becomes central. Now, we would like to then move on to the issue of, which is going to be central to this matter. That's the issue of the leave of absence. Why is that central? Remember the issue about the interplay between the decisions. So that decision is central in the sense that in relation to the acting minister stroke Cachalia decision, it is purportedly, well, put it this way, there would have been no need to appoint acting minister Cachalia if the leave of absence decision had not been taken. Or, to put it differently, had that decision not been taken, then the president would have been free to appoint Professor Cachalia as a minister. That's self-evident. So that's the centrality of that decision. On the other hand, as I've already said, its relationship to the commission is that presumably, my learned friends I'm sure are going to argue this, presumably the leave of absence decision is pending the commission. We will go as far as to say, Justices, that if we are correct that the president, and we are convinced that we are correct on this, does not have the constitutional power to place a minister on leave of absence. If we're correct, for a minute, let's just assume we're correct on that. If we're correct on that, then the question as to whether that decision, once it was taken, was rational or not rational, does not even arise. Because if it's ultra-virus, it's ultra-virus. It doesn't matter whether it's rational or not rational. And if we're correct in that decision, as I say, then the second decision on the appointment of the acting minister also must fall together with it. Now, that is the canvas against which we're going to approach this matter. The next point which I'd like to highlight is that obviously at the back of all this is legality. But we are going to talk about legality in three dimensions. Let me put it that way. And I'll use some shorthand that I know this court is familiar with. So we talk about illegality in the third-shore sense. What do I mean by the third-shore sense? And I'm paraphrasing. We all know that the third-shore decision is a pivotal decision which says that the executive, including the president, or any functionary for that matter, may only exercise powers conferred on them by the Constitution or legislation, or by law. Once you stray outside of what is conferred on you by law, in other words, unlike a human being, you can't just do what you think is right or what looks, you must do that which you are empowered to do. And then there's legality in what we call the Albert sense. And that is the rationality, the standard of rationality, which says that there must be a connection between the means and the ends. And all the cases, pharmaceutical, Albert, and so on. Then there's an area of legality which is probably neglected, which was articulated, I think it's paragraph 3 of the Law Society case, Law Society versus the President, which says that a fatally tainted process renders the decision irrational. And this is what is said in that paragraph. Our president is never at large to exercise power that has not been duly assigned. So that's a rehash of the Fetcher statement. And then Mogoeng CJ went on to say, crucially, public power must always be exercised within constitutional bounds and in the best interest of all our people. Always we talk about this rationality in these dry technical terms, but that qualification that for it to be rational, it must also be in the best interest of our people is often forgotten. And in the context of this case, that raises a few rhetorical questions. Is it in the best interest of our people that we have yet another multi-billion commission which may or may not yield any outcomes? So that, as I will demonstrate, the community and the public can be sanitized and numbed into forgetting. By the time the commission report comes in 3-4 years' time, everyone would have forgotten what the issues are. Is that in the best interest of our people? Is it in the best interest of our people to have 2 ministers holding effectively the same portfolio, being paid over the next 3-4 years, 2 salaries, one sitting at home doing nothing, the other one acting in his place? Can that ever conceivably be in the best interest of our people? And more closer to home, is it in the best interest of the people to have the president doing all these maneuvers of this one is acting, this one is now acting in the place of the one who's acting, to the extent that as we're standing here now, we have 3 ministers of police. One in his absence, in the leave of absence, the other one acting in the place of the acting one. Can that ever conceivably be in the best interest of our people? That's what the people want? On top of the already bloated cabinet that is already there. And is it in the best interest to treat the same situations differently? And I'm being generous here. To know, one day, as the decision maker, that you are at large to dismiss a Deputy Minister Whitfield for merely going overseas without permission. Assume that is such a bad thing. But the following day, you don't know that. Suddenly you say, no, I can't. How could I ever dismiss a minister on untested allegations? Is that in the best interest, that a person given so much power as a president, and this court explained in the EFF1 case, the enormous power that is wielded by a president in South Africa, that a person with that much power should be allowed to do that, to amplify that power illegally, as we're going to demonstrate. Now, let me just pause there. I'll come back to the merits. I want to deal very quickly with the preliminary points. In my understanding, well, if judging by the heads and the practice note of the other side, the issue of urgency is not contested. Certainly not contested by Minister Mchunu, and it is kind of half-heartedly contested by the President in the papers, and linked to the so-called prematurity point. So the real preliminary point is exclusive jurisdiction. Now, I just want to say this. Again, if you look at the papers, you'll notice that the opposition to exclusive jurisdiction is really, as I say, not so vigorous. But it's very rigorous in the heads for understandable reasons. I would also spend 18 pages on exclusive jurisdiction if I had a case like the other side has. But the issue is very simple. The issue is this. What are the president-specific or so-called agent-specific obligations that are at play in this matter. And I want to say this up front. The fact that those agent-specific and president-specific obligations might be mixed up with other general obligations is neither here nor there. Because I'll be the first one to accept, for example, that the obligations that are in Section 96 of the Constitution do not are not only assigned to the President, but to all members of the Cabinet, including the President. But the test is simply that we're talking about the Chapter 5 obligations. Nobody in their right mind can debate the fact that to the extent that there are obligations in Chapter 5, those are President-specific obligations, because after all, that chapter is called the President, or at least the first parts, and to the extent that he appoints the Cabinet, that must be read within the context of Section 85. 85.1 says that all the executive power is vested on the President. And then, of course, he has the right to get assistance, to put it colloquially. Now, here's the fallacy of the argument on jurisdiction from the other side. They seek to read too much into the fact that some of those obligations are coupled with discretionary powers. But I'll demonstrate that that's completely, that's really just gilding the lily. The issue is this, and I'll just take one example. So the power says you may dismiss. No, let me take the Section 98 example. The power there says you may, and I'm paraphrasing, you may appoint a cabinet minister to act in the stead of another one. Now, the other side would like us to believe that because that power is expressed as you may assign those powers to the acting, therefore, well, that's the end of it. That means it's a discretionary power. There's no obligation or duty. But that's fallacious logic. Our courts have said many times that you may have a discretionary power, but within it embeds duties. Let me explain that using the same Section 98. So it might be discretionary to appoint an acting minister or not. In other words, you may decide not to appoint an acting minister. But once you have taken that decision, then you have a duty to appoint a cabinet minister. All right? So you can't be mesmerized by the fact that there's a word may in that sentence. Because once you've now chosen that, and the example I was giving to my juniors was, well, I have an option to go on holiday overseas or in South Africa. But once I've decided to make the decision to go overseas, then I must have a passport. I now have a duty. So the fact that the first decision was optional does not negate the duty that is embedded. Now, once that is understood, then the entire attack on exclusive jurisdiction must fall away. Because self-evidently, those duties are on the President, let alone the fact that they are now coupled with Section 83B duties, which are clearly the presidential powers. And let alone the fact that they are also traced on the presidential oath of office. And I'm sure my learned friends, whatever they're going to say, they're not going to say that the duties that arise from the presidential oath of office are not specifically assigned to the president, only as an agent. So that should be the end of that. This case, with the greatest respect, is even stronger on the issue of exclusive jurisdiction than EFF1. Because you'll remember in EFF1, there was Section 83 obligation to anchor, but it was then coupled with, I think, Section 182, which was the power or rather the duty to obey remedial action. So in a way, you had two weak rights combining to give exclusive jurisdiction. Here you have two strong rights emanating from 83, rights emanating from 92, rights emanating from 98, rather duties or obligations from 98, and also from the oath of office. If we're wrong about that, then clearly this is a case that cries out for direct access, because nobody in this country is going to be able sustainably to say that this is a matter which must, traverse the entire distance to the High Court and to the Supreme Court of Appeal, and one day in 5 years' time come here. That, again, my learned friends are not going to suggest that. Let alone the cynical problem in that proposition, which is that not only must the public be paying for another 3 or 5 years 2 salaries for 2 ministers, but it must also pay for litigation in the High Court, in the SCA, and so on, just for the matter to be resolved. That's only an insensitive person can suggest that is what should happen. So before my free time is gone, I want to go back to the issues on the merits, and I'm going to, as crisply as possible, just outline on each topic what we say are the constitutional problems. Topic 1 is the leave of absence. As far as the leave of absence is concerned, justices, we say the following. As I've already said, the president does not have the power to place a minister on leave of absence, full stop. All the parties, fortunately, agree that there is no such express power, that nobody has to go there. So the best case for the other side would be to rely on some kind of implied power, because we all agree that it's not there. If it was, we would all see it. And we will demonstrate that on the test put by this case, rather by this court with respect, in Amabungane by Madlanga J, and as complemented in Mwabe by Majid J. On that test, which in any event is an accepted test, the test of necessity, you cannot have an implied power unless that power is necessary to exercise the one that is primary. That's just as simple as that. Sorry. If I may, just express that proposition. Hoekstra, in the latest book on admin law, expresses the test of necessity beautifully as follows. Starts by re-expressing virtue. It's consonant with the principle that repositories of power can only exercise such power as has been conferred on them by law. Implied powers may, however, be ancillary to the express power or exist as a necessary, and that's where the test is, or reasonable consequence of the express power. And this is the beautiful example she gives. Just as the power to make omelets must necessarily include a power to break eggs, so the power to build a dam may include the power to expropriate property or to remove silt. And then she makes other examples. In other words, for an implied power to arise, it must be a necessary concomitant of the primary power, the one that has been expressed. So how do we bring that home here? You would have to find a formulation, absurd as this might sound, that says that the power to dismiss, for the power to dismiss to exist, it is necessary in the legal sense that you must also have the power to place a minister on leave of absence. Ha.
The clock is, here's the clock, Mr.
Thank you.
Thank you.
Well, it seems like your clock moves faster than mine.
You'll have to take it for
Yes.
that one.
Thank
Mr. Mpofu, let's just deal with the last point.
This point on
One that
implied
I
powers.
think-
Yes. Thanks, Justice.
You rely on the Masitla principle. I'd like to take you, I'd like to take you to the Masitla.
Masitla. Okay, yes.
Para 68 of
Right.
Masitla, where the court says the power dismiss is necessary in order to exercise their power to appoint.
Yes.
And then at the end, it says there is no doubt that the power to appoint under that section, which is 2092 of the Constitution, and the power under ISA implies the power to dismiss.
Yes.
And somewhere there, it then says that there will be other ancillary powers. You don't just get to dismissal, you may do other things. So in this case, are you saying the president does not have any right to do anything other than dismissing? He cannot suspend a minister or place him on leave? And if so, why?
Yes, thank you. There are about 3 or 4 reasons, but let me move through them very quickly. The first one is that the Masatla case, although it's applicable, is distinguishable in the following sense, that Masatla, as we know, was an employee in the end. And that, by the way, lies at the heart of where the problem is, because the other side treats this situation as if it's an employment situation, which it is not. But that's not even the biggest problem. The relevance of Masatla to this case is peripheral, and I'll explain why. It's relevant in the sense that it gives us the theoretical understanding of implied powers, and everyone has applied it, and so that's not controversial. But if you look at the 2 powers that were in contention in Masatla, which were the power to appoint and the power to dismiss, we don't need that in this case, because in section 92, those powers are expressed, both of them. It says, section 92 says the president appoints and may dismiss. So we don't need Masatla. The proposition in Masatla is actually incorporated in section 92. But if you want to apply Masatla to this case, you have to go further and say that the power to dismiss implies the power to place on special leave. And what I was saying when the clock went is that that proposition can only hold true if the power to place on special leave is necessary for the execution of the power to dismiss. And that is surely that cannot be the case on the test in both Amabungane and Mwabe. So the Masatla principle we accept. And, but we're saying that on the issues before this court, the power A cannot be, or power B cannot be implied from power A, the powers that we're dealing with here, not the power to appoint and dismiss. Yeah. So that's the second answer. In other words, Justice Mhlanhla, okay, maybe let me make it even sound, show that the 2 things are not related. So one of the issues we make, for example, is that by the way, there's no such thing as placing a person on leave of absence. So you can't have a power to do something that's just senseless. Leave of absence, by definition, is something that you ask for. It's not something that can be imposed on you. Right? So, leave of absence is something that is granted. So, that power to grant, or rather, the power to place someone on leave of absence is non-existent on its own right, without it even being linked to the power to dismiss. But in this particular case, the hurdle that the other side has to pass really is the hurdle of necessity. Now, here's the test, the issue, Justice Mchunu. In which world can we say that it is necessary for you to exercise the prerogative power, which we know is wide, and you don't need reasons. You can literally remove a minister and just say, and if they say, what have I done wrong? You say, no, you have not done anything wrong. I'm just removing you.
Now tell me, Mr. Mpofu,
Yes.
on that point, is there anything wrong if a president, because what you're saying is, and accept that there's a difference between an employee who would be subject to labor law
Process.
yes, and a politician. Now, if a president decides that out of fairness, he doesn't want to just dismiss a person, he wants to give a person an opportunity to respond,
Yes.
is there anything wrong with that?
No, there's nothing wrong. It's just illegal. You can't just somewhere say, okay, for this one, because he's my friend, I'm going to give them a hearing. When I know that, and that's why it goes back to this necessity, I know that it is not necessary to do so. For that question, Justice Mchunu, is pregnant with the admission that it is not necessary. It's just, nice to do. That's not the test. The test is that it must be something that is necessary. How can it be necessary to give due process to a person that you can willy-nilly dispose of? We're not talking about kindness here and all those things. We're talking about constitutional obligations. So so there's no rational link between making that decision and the power, because the power is vast, it's big, it's prerogative. It comes from the royal prerogative. That's where it comes from. The royal prerogative was this notion that the queen or the king is only second to God. They can do no wrong. We know that in constitutional terms, that notion has been attenuated, but it is still a wide power of prerogative power. So one cannot just say, is there anything wrong, in the general sense? Well, I mean, if there's a stipulation, let's say, Justice Mchunu, that says you must answer, I'm putting charges to you and you must give it to me in 7 days. And out of the kindness of my heart, I say, I'm giving you 30 days. I can't say it's wrong. But is it necessary? No. Sorry, Justice. Yeah, it looks like you wanted to follow up.
Well, I'm carrying on with my questions.
Yes. Yes. No. Okay. No. The only point I want to make here is that if as we strongly contend, the implied power reliance which is based on the test of necessity. If we are correct on that, then that's the end of it, as far as the legality is concerned. But if we are wrong, then we say that the rationality of that decision is not there. And I've already said the first reason why. It's because there's no rational connection between the two. The second reason was the other one I mentioned earlier, which is that in any event, you can't place somebody on. So no law, no constitution in the world can empower you to do something that is illogical, such as placing forcing someone to do something that they should be asking you for. That just should be self-evident. So that's on that point. That's
Okay. On the next point is on the appointment of the professor,
yes,
acting minister.
yes,
Let's just unpack that. There's this argument on behalf of the first respondent that the challenge is premature
yes,
because in terms of Section 101, any decision by the president must be in writing. And that has not yet been. He made the announcement on the 13th of July. But the actual appointment, from my understanding, it's still yet to be made.
yeah,
If you can just deal with it
Address
for me,
that, yes.
and also address, my understanding of the section is that only a cabinet minister may be appointed as an acting minister.
correct.
Now, in this case, what do we have?
Yes, thank you. With respect, Justice Mhlanhla, I'm not going to spend a lot of time on this because, with the greatest respect to my learned friends, I don't understand what the defense is here. So, quite frankly, there's no defense. But to the extent that it is attempted, I'll use your questions. And the reason why I say there's no defense is because, my learned friends, we point out in our papers that, as you correctly say in your second question, you can't. That's why I was saying you have a duty. Once you've made the decision to have an acting minister, then you have a duty, according to Section 98, to put a cabinet minister. The president, in his public announcement, said that he is exercising his powers in terms of Section 93. 91(3)(c). That alone should tell you that there's a lot wrong with this picture. He doesn't even mention Section 98. Only in the answering affidavit, when they deal with that topic, what is the first paragraph? They talk about Section 98. So it's an afterthought. What that shows is that when the decision was being made, he was doing it under Section 91(3)(c), which we all agree entitles him to appoint a minister, or rather a minister who's an outsider, quote unquote. In other words, not a member of the National Assembly. Nobody is quibbling with that. The problem with this president is he literally wants to do what is called, you want to have your cake and eat it too. So he wants to appoint Professor Cachalia, but he wants to save Minister Mchunu and not dismiss him. Rightly or wrongly, and I'm not even there. That's really, this whole maneuver is about that. How do I save my friend and close political ally, give him a salary for the next 3 years, 5 years, God knows for how long, while he's doing nothing, but keeps the bodyguards, the drivers, and all those things, and the title, but at the same time, I have someone who must look after the police. So then you think of this long, elaborate contrivance. But the law is very clear. You must do one or the other. If you want Professor Cachalia, then you must dismiss Professor, yeah, maybe, maybe that's where he should be, not in the academia. So it's very easy, Justice Plant. It's very easy. You want Professor Cachalia, then you must dismiss Minister Mchunu. Conversely, if you look at it through the eyes of Section 98, you want someone to act in the place of Minister Mchunu, then you must get someone from the cabinet. It's really simple. And surely, one of the purposes of the constitutional drafters was to save the money of the long-suffering taxpayer, so that when there's an acting minister, you take from the existing ministers. So nobody else, they don't have to be sworn in again. They don't have to get another salary. They don't have to get another bodyguard and all the things that go with it. That surely must have been the purpose of that section. But no, you want to breach it and get somebody else who's going to have their own bodyguards, their own salary, and so on and so on. So the president is very simple. He must choose. He can't have it both ways. You can't breach 91.3c by, or rather abuse 91.3c by all these gymnastics that we see now, of saying, no, he's not really acting, but he's a minister, and I don't even know how to explain the kinds of things that are written here. Because you don't need those gymnastics. It's very simple. You have a right to get anybody, a professor or an accountant or whatever you like, but you must only do that when you are appointing the yes. So that, with the greatest respect, that is that case is non-existent on the other side.
My last question for now, Mr. Mpofu. Could he have maybe, in order to comply with Section 91.3c,
yes,
when he was making the appointment, the announcement said, I'm appointing Professor Cachalia as a minister, and I'm allowed in terms of Section 91.3c to appoint someone from outside as a minister. And then later on, after Professor Cachalia has been appointed as a minister, he is now a member of cabinet, then appoint him as an acting minister, as
an acting minister
of
police.
Of
I get
police.
the question.
Yes.
No. You see, that would be another contrivance. Because remember, Section 92.1 says that the president appoints deputy, 91.2, sorry, appoints deputy and president and ministers, assigns their powers and functions, and may dismiss them. Let's put aside the issue of dismissing for now. So you can't have what in Britain is called minister without portfolio. We don't have that regime because of that section. And in the course of the gymnastics, this was tried in the public domain, but it was soon abandoned wisely. Because when they were trying to backpedal now and try and stop the obvious problem, fortunately, it was abandoned. Well, not exactly. There's some undercurrent in these papers where they try to sneak it, but not boldly enough, because it would be illegal. But, Justice, let me go back to your first question. The first question that you asked is, again, and I say this genuinely, I'm disappointed that the president can try and do this, really, or any president. The president told this nation the following. I'm reading from page 39. In order for the commission to execute its functions effectively, I have decided to put Minister Senzo Mchunu on leave of absence with immediate effect. Then he says, I have decided to appoint Professor Firoz Cachalia as acting Minister of Police. What is so difficult about that? It's a simpler, I have decided. In English grammar, it's called the past perfect sense. Okay? I have decided. It's not I'm going to decide, or I have decided to appoint him as acting minister, not as minister, and that goes to your second question, Justice Mchunu. As acting Minister of Police. It's as clear as mud. So you can't backpedal when the problems have now been shown up. You start now coming with all these things that we hear. And if you think that's nitpicking, look at this. He then says, I am appointing Professor Cachalia in terms of Section 91(3)(c). Okay? So again, it's very clear. That one is called the continuous present tense. Okay? And then, just so that we know that he is not, his grammar is not a problem of grammar. He says in the next paragraph, I will appoint an acting minister from within the cabinet until Professor Cachalia takes up his post at the beginning of August. That one is called the future tense. So that means he knows that he will appoint minister. Now, where are we now, Justice Mchunu? We're in a situation where he has already done the appointment of Minister Mantashe. So for you to believe the kind of obfuscation that is being given here, you must believe that the decision that he said he will do has come before the one that he says he has already decided. And what is that? And so it's really just really insulting the intelligence of South Africans, because you don't call South Africans on a Sunday to listen to you and tell them this, and then you try and do the kinds of shenanigans that we have here. So, and in Mwabe, Justice Machit also dealt with this issue about the public announcement. In a nutshell, what is said in the Mwabe case is that the decision, once the public announcement is made, that's when the decision is finalized. And here we know that the public announcement has been made. So there is no way. That sentence is where the problem is. I have decided to appoint Professor Firoz Cachalia as acting minister. That goes to your question, Justice Mchunu. Because if he had just said, I've decided to appoint Cachalia as minister, there would have been nothing wrong. But if he does that, then what does he do about his friend? He has to make sure that Minister Mchunu gets his salary and bodyguards. And that's why the whole obfuscation and myopia that you see here, and constitutional breaches. So that's the second decision. As I say, we don't need to spend time. That one is self-evidently just illegal, irrational, not empowered, ultra-virus, whatever and not in the interest of our people. So it covers it ticks all the boxes.
Mr. Mpofu, let me allow my colleagues to ask questions.
Okay, thank you, Justice Mchunu.
Justice Chiku.
Mr. Mpofu?
Yes, Justice.
You were reading from the announcement from the president.
Correct.
And he does say that he is appointing Professor Cachalia in terms of Section 91(3)(c).
Correct.
You don't have a problem with that because he can.
No, I do. I do. You can't do that. You can't appoint someone in terms of 91(3)(c) as acting minister. That's why the thing doesn't make sense.
Well, there are different sentences. I thought that you said that was in the future tense.
No. Okay.
What is in the future tense?
No, what is in the future tense is Gwede Mantashe's appointment, Minister Gwede Mantashe's appointment.
Appointment.
Yes.
Okay, all right. So he said he's appointing him in terms of section 91(3).
C, yes.
C, and does he say, I'm appointing him as an acting minister in terms of section 91(3)?
Yes, that's what he's saying, Justice Chick.
Can-
Let's say,
can
it says
you read it?
one,
Can you
two-
read it?
Oh, sorry, okay.
Please read it for me.
Yes, okay. Sentence 1, 2, 3, 4, 5.
Yeah.
Start with that one.
Yes.
I have decided to appoint Professor Firoz Cachalia as acting Minister of Police. Simple.
Ends there, yes.
Yes.
And then the
Next,
reference,
yes.
then the reference to section 91(3).
Yes, but then he says, in the same breath, I am appointing
Not
Professor
in the same
Cachalia in terms of section 91(3)(c) of the Constitution, which empowers the President to select no more than 2 ministers, not acting ministers, from outside the National Assembly. In
Yes,
other words,
I want us to take it step by step, because the
Yes.
reference to 91(3),
yes,
he doesn't say as an acting minister in terms of section 91(3). So that one is a standalone sentence that is appointing him in terms of section 91(3)(c).
outside of what he just said a minute ago.
Yes, no. I understand. I'm saying there are 2 sentences. Where I'm getting to, Mr. Mpofu, once he's appointed him, I'm saying he's got a right to appoint a minister
Yes,
in terms
absolutely.
of section 91(3).
Yes,
And he appointed Mr. Cachalia in terms of that section. That's what he says. And your problem is that he appointed him as an acting minister.
not, yes, that's his problem. It's the President's problem.
Okay, that's your complaint.
Yes,
Okay. That is your complaint.
correct.
That's fine.
Yes, that's my
Your
my
complaint.
complaint. Correct.
Now, where I'm getting to is, once Professor Cachalia is appointed in terms of 91(3), does he not form part of the cabinet?
No, Justice Chick, with the greatest respect,
No. I'm trying to unpack this thing for you, with
Yes.
you, so that
If
now,
not,
when I come out of here, my thinking is very
yes, no, I understand.
So this is why I was saying, let's separate these 2 sentences. And I'm asking now, and I'm not telling you, I'm asking
Yes,
whether when he then gets appointed, he becomes part of the cabinet or not.
if you mean.
If he is appointed,
Yes.
I'm asking if he becomes
Yes.
a member of
Yes.
the cabinet.
If, in other words, Justice Chick, well, let me put it like this, just so that it's out there and I get it out of my chest. As I said earlier, this announcement must be seen as a package. You can't isolate pick and choose and cherry pick the parts that you like outside of the.
That would be inappropriate. That
No,
would
I'm
be
going to answer the
inappropriate.
question. I'm prefacing the answer. I'm saying the announcement is the announcement. That's the conduct. So it's inseparable. Once the egg is scrambled, you can't unscramble it. But let's come to directly to your question. Of course, and I've said this in my address when I was on the uninterrupted time. We would be foolhardy if we came here. If the president said, I have decided to appoint Professor Cachalia in terms of 91(3)(c), which empowers me to select no more than 2 ministers from outside of the National Assembly, what would we be doing here? Nothing. Because he is empowered to do that. I've already said that. The problem, or the complaint as you put it, that I have, is that he says that in the next sentence, after having said he's appointing him as an acting minister. And the only reason he says he's appointing him as an acting minister is because there's the ghost of Mchunu, which is not going to die, which is sitting there.
I actually don't want us to go there.
Well,
You know,
that's what it is.
Because I'm trying to look at this without involving the politics around it.
No, it's
He's
not
a
politics. It's
no.
Mchunu.
I'm saying, let's get to it step by step and focus on actually understanding. You know, because you've got a problem with the term acting. And I'm not going to ask you what the president has said about the fact that acting is just there as an acting. So what I was asking you to help me with is whether after his appointment, he becomes a cabinet minister or not.
That's the question.
Yes.
Yes, yes. Anybody who's appointed in terms of Section 91 becomes a minister after appointment, whether they come from the National Assembly or come from wherever. They become a minister, yes.
So once he has become a minister, then the president, and the reason, if you can just be patient with me, you know that there are certain ministers, for instance, who are ministers in the presidency. You've said that in our country there are no ministers without portfolio, but you do know that there are ministers in the presidency. I'm just making an example of that. Once he has been appointed as a minister and he is part of the cabinet, is there anything preventing the minister then from then saying, okay, you are an acting minister?
No. If there was something wrong with that, Justice Chick would be attacking the appointment of Minister Mantashe. How can there be anything wrong with appointing a minister as acting? That's what Section 98 says.
So what we are attacking, the complaint is the fact that the minister in his press release, the president in his press release said that I'm appointing Professor Cachalia as an acting minister. The use of the word acting when he was making the press release.
No. It's not about the press release. Go to page 91 of the President's affidavit. Paragraph 57.
It's in page?
91, Justice. Paragraph 57, the President says, long after the announcement, last week, I have outlined the above reasons why, given the nature of seriousness of allegations against Minister Mchunu, which that's what it is, it's not politics. I have elected to appoint an acting Minister of Police from outside Cabinet, as I'm entitled to do in terms of Section 91(3)(c). That is wrong. There's no such, that sentence, which is not in any announcement, is constitutionally confused. I've elected to appoint an acting Minister of Police from outside of Cabinet. You can't do that.
Okay, all right, Mr. Booth. Thanks about those responses. Even though I can read from your body language, you are irritated with me.
No, I'm not.
Can you both take a deep breath?
I'm very happy with you, Justice Chick.
Can you both take a deep breath and proceed?
Okay. No, I'm not. I really am not. Maybe I'm just not looking as I should. But on a more serious note, Justice Chick, I get what you say, and that is why I said in my address, this thing would have been if one didn't want to do these machinations, which you call politics, then this thing would be very simple, because the president would have done exactly what you're saying. He would have simply said, "I've looked at this thing." He had two choices, by the way, because our learned friends keep on saying, "Well, they're goading us. Yeah, why are you saying he must dismiss him? He must dismiss him." Forget about dismissing. He had a choice to retain him. He could have said, "I don't care what Mkhwanazi is saying. I'm retaining him." But once you decide to retain him, then obviously you then can't have someone acting in his place. Or he could have dismissed him. And had he dismissed him, then what you're saying would apply. it would have been...
Let's move to another point.
yes.
Perhaps this will also need some kind of a patience so that you can explain this to me.
Yes.
I'm looking at the Constitution concerning exclusive jurisdiction.
Right.
And in my thinking, I'm saying the complaint concerns the exercise of a power and how the president has exercised the power. And yet the Constitution talks about failure to fulfill a constitutional duty. So what's this constitutional duty that he has failed?
Okay.
Because I thought that the complaint is that he established a commission of inquiry and he put Minister Mchunu on special leave, and you disagree with that. You disagree with the fact that he adopted that approach. You disagree with the fact that he appointed a commission of inquiry. And then the third one was the appointment of Professor Cachalia as an acting, as an acting minister instead of just being a minister. So now I'm grappling with what is the constitutional duty that he has failed.
All right.
To
Thank you.
fulfill.
Thank you, Justice Schick. Okay. What was said in the EFF1 case, and my vote counts, and all the other cases, is that the failure, and that's in any event a reflection of 167(4)(e). Once the complaint is the failure of the, remember, sorry, I'm sorry to do this, but let's start from the beginning. According to Gaba, this court said, when you are looking at jurisdiction, you look at the pleadings, what is alleged. Whether we're going to win or not, that's a different matter. But what has been pleaded, okay? So what has been pleaded in this case is that in doing all these things, and I'm not going to count all of them, the president failed to uphold the Constitution in terms of Section 83B, okay? Now we know from EFF1 that that is not enough, because otherwise it would mean every time the president does something, you say he failed to do, to uphold the Constitution and so on. So there are, what shall we call it, limiting mechanisms which say that that broad power in 83 must be coupled with a specific, agent-specific presidential power, right? What, therefore, are the agent-specific powers that are at play here? I've already made the example again when I was doing my introduction, that just let's take the discussion that you and I were having. Once the president decides to have an acting minister, as it says here, then he has a duty, a constitutional obligation to ensure that that person is a cabinet minister, right? An existing cabinet minister. So that's one. Two, I'm just using that as an example. There are many other, I could use 91(2) as well. Yeah. But let me jump to what I call the constitutional, or rather, the oath of office. In his oath of office, which obviously only accrues to him, he has undertaken to follow the prescripts of the law to the best of his conscience, not to favor his friends, as we have alleged, rightly or wrongly. But we have alleged that this is motivated by his personal affinities with Mchunu. We've alleged it. Are we going to prove it? I don't know. But we have alleged it, and that is a breach, at least a prima facie breach of his obligations to exercise his conscience and not do strange things like that.
Okay.
So,
Let's move to something else.
Yes.
Because my colleagues, I'm sure they are very eager to ask their own questions.
I don't think so.
Are you still proceeding, continuing with the challenge against the establishment of the
Yes,
Commission of
thank you.
Inquiry?
Yeah, in fact, thank you, Justice Chicko, for asking that.
The reason I'm asking that, other than the fact that you haven't had the opportunity to deal
Yes.
with it, is that I think I saw somewhere in your, I think it was in reply, where you said that Mr. Mchunu's defense or something to that nature would best well be dealt with in the Commission of Inquiry.
No.
And maybe and it gave me an impression that you actually now probably thinking that perhaps a Commission of Inquiry is not such a bad idea.
No. That's what they say in their papers. They are completely wrong in their heads. Let me explain why. Well, let me start with your very last few words so that it's clear to everyone. Standing here, we do not say that the president does not have the power to appoint commissions of inquiry. Nor do we say, although with all the quibbles about the taxpayers and so on, as covered in the article that we submitted yesterday by Michael Bishop. Nor are we saying that the commissions per se, forever amen, are a wrong mechanism. Because there are some redeeming features about commissions. It has been said correctly, I know this from personal experience, that they can also be accountability mechanisms. In other words, assuage the public's right to know and so on. No, that's not where we are. Let me tell you what our case is, not the one that they want to answer, which we didn't plead. Our case is as follows. Two things. One, we say on the specific facts of this case, the president had no, let me put it this way, it was irrational for the president to appoint a judicial commission of inquiry. Okay? Now, there's a difference between a judicial commission of inquiry and a commission of inquiry per se. Section 84(2).
Mr. Ofu, I'm sorry, I'm now conscious of the fact that
Yes.
we've been debating quite
Yes.
a long time. So I want to be fair to my colleagues. You do know that the president is saying that there are different stakeholders that have been implicated here. It's not just the judiciary. It's
So do we.
SAPS and
Correctional services,
Correctional
Metropolis.
Exactly. And when I was thinking about it, I was thinking that, for instance, I think that in your heads you made mention of an alternative that could have been pursued was JSC and Magistrates Commission.
No. That's a different.
That was not you.
No, it was me, but that's a completely, it's unrelated to what we're debating. I'm coming to the JSC point. Let me explain, Justice Chick, if I may. Yeah. What the JSC point is a different one about usurping the powers of the JSC. I'll come to that.
No, I'm actually not on that point as well. I'm simply saying, as an alternative, I didn't think that the JSC and the Magistrates Commission would be the suitable.
No, you never said that.
You never said they could be the suitable option.
No.
Okay, all right.
Okay.
Continue.
So this is what we are saying. We are saying that, Justice Chico, let me make this graphic for you. We say on the facts of this case, for the first time in South Africa, a lieutenant general says that after police investigations, they have found that the judiciary is involved in crime and corruption and all the things, the sordid things that Justice Kwanazi.
And the president's take on that is that it's highly unlikely that they would implicate judges of this court, because criminal cases starts at the magistrates' court at a lower level, and then perhaps the high courts.
No.
And then he says that when he decided to speak to the Chief Justice, he had this in mind, that at least this court would not have been dealing with matters pertaining to criminal investigations and all of that.
Firstly, the president never said that. That when he spoke to the Chief Justice, he had in mind that, he said he spoke to the Chief Justice about the identification of the judge. So he never said that. Let's be fair to him. Yeah.
In his heads of arguments, what does he say?
No, he says the following, which is an afterthought. It's what we call ex post facto rationalization. He now says that in any event, Justice Madlanga would be untainted by the accusation, by the Mkhwanazi accusations, because of what you've just said. Because criminal cases start in the magistrate. But so what? Criminal cases also come here.
But Mr. Mpofu, you know, you separating what he said in the affidavit and in his heads and all of that, it just gives me problems, because I'm trying to summarize what his version is.
Well, I'm afraid, Justice Chick, if I'm not allowed to correct what you are saying.
No, you
the
are
president
allowed.
did not say that
You are allowed.
Yeah, he never, I can assure you now, I've read these papers 1,000 times. The president of South Africa has never said that when he spoke to the Chief Justice, he did so because of that other thing that he says about the Constitutional Court cases. He never said that, to be fair to the president. So I was simply trying to explain that. If it's here, someone else will show it to me. But it is not here. The president says two things. He says, in identifying the judge, so I spoke to the Chief Justice to ensure what he calls the legitimacy and gravity of the commission, and therefore we agreed on the acting Deputy Chief Justice. He says that. In a different place, when he's now talking about the fact that Lieutenant General Mkhwanazi implicated the judiciary, he then says, well, in any event, I am of the view, I'm reliably informed, something like that, that the Constitutional Court judges could not be covered in the he says, this is at page 81. There is no suggestion by Lieutenant General Mkhwanazi of any impropriety at the level of the justices of the Constitutional Court. The allegations implicating members of the judiciary pertain to criminal proceedings. Where he gets that is I don't even know where he gets that. And then here's the part. As far as I have been able to ascertain, that's the expression I was looking for. As far as I have been able to ascertain, none of the proceedings to which the allegations relate was ever referred to the Constitutional Court for adjudication. Well, this statement is fraught with illogicality. Firstly,
but who is saying this, Mr.?
It's the President of South Africa.
Yes, and when I was engaging you, I was summarizing what was in the founding affidavit and what is in the heads. And I'm talking about a version here, and I'm not quoting verbatim.
Okay, thank you. Yeah, you are right, Justice Chick. But the point I'm making is this. Let's look at it. Let's look at it on its terms. Let's look at it on its terms. Not worry about whether it was linked to the Chief Justice or not. Let's forget about that. Let's look at it now on its terms at paragraph 27. I'm saying this thing is fraught. It's fraught. Sorry. It's fraught with illogicality, Justice Chick, as follows. You can't come for the first time in your answering affidavit and say that there's no suggestion in Lieutenant General Mkhwanazi of any impropriety at the level of the justices of the Constitutional Court. Where does that come from? Justice Madlanga, who's part of the judiciary, all Lieutenant General Mkhwanazi said was, he never said, judges, in the magistrate court, in the high court, in the SCA, in what he said, the judiciary as an institution is implicated in drug dealing, in the cartels, in the money laundering or whatever the things. Now, let me say this very clear. I am sitting here, now I'm speaking for myself. I do not believe that those allegations, cover the entire judiciary at West. It would be ridiculous. But that's not the point. The point is this, Justice Chick. The institution, and the President uses that word, by the way, in his announcement, or rather in the terms of reference. The institutions that have been accused include the judiciary. Now picture this, Justice Chick, in your own mind. We are in a court of law. Complainant is Lieutenant General Mkhwanazi. And he says, the accused are the Metro Police, the judiciary, the correctional services, politicians, and so on. They're lining up here. And you then say, one of the accused must go and be the judge. Oh, sorry.
Okay.
You look like
Mr.
an
Prof,
accused.
for now, let me allow my colleagues, allow my other colleagues to pose their questions. If there's a burning question I feel
Yes.
I need to ask you.
Maybe then, Justice Chick.
I'll ask that.
Yes, thank you. Can I just take advantage of the fact that we touched on the JSC thing so that I just complete that point? Yes. So the point about the Nemo Udex, which is an obvious principle of our law, that you can't be the judge in your own way, you can't be an accused and can't be a referee and a player, as people would say in the street. It's a simple concept of law. So that's the first thing. But we then go further and we say that in any event, even if this was not even if this was a non-judicial commission, so to speak, and we know we've had those. We had the TRC had a bishop as a chair. The Muarane Commission had an advocate as a chair, and so on. So there's nothing that compels the president to have a judge. But we say even if this was we say even if this was a non-judicial commission, it would be problematic for a second reason, which is that you would be imbuing that commission. Let's, for argument's sake, call it now the Muarane Commission, not the Matlanga Commission. You would be imbuing that commission with the power to investigate the conduct of judges. Okay? That function is constitutionally and exclusively preserved for the JSC. So you cannot usurp the powers for all the reasons that we know, to preserve the independence of the judiciary and so on and so on. You can't now have a new entity called the Madlanga Commission or the Muarane Commission or whatever commission for that matter, or the My Nature Commission. You can't have that commission investigating the conduct of judges, because there are constitutional reasons why that function is specifically preserved for the JSC or the Magistrates Commission. So that's a second reason, assuming we're wrong about the first one of Nemo Udex. But those two, so please, nobody must say we're saying there should be no commission. We might think it, or the public might think it, but we're saying that in this part, on these facts, a judicial commission, when the judiciary is one of the accused, is constitutionally inappropriate. Thank you. Sorry.
Thanks, Mr.
Thank you.
Thanks, Justice Mhlantla.
Thank you, Justice Mhlantla. Mr. Mpofu, if the President had said that he's placing Minister Mchunu on suspension with full pay, would the applicants have been able to advance the arguments that that are being advanced on their behalf today.
If he said he was placing him on suspension with full pay, well, at least one of the arguments that we're advancing would not be competent, which is the one about imposition, because a suspension, as we all know, is something that is imposed. But the other arguments
Are
would
we
still.
playing with words in terms of leave of absence and suspension when the one might mean the other? And are we placing form over substance?
No, Justice. You see, the president. Let me, and again, since I was listing disappointments, this is another disappointment, because the president seeks to mislead the court by creating, to justify that by pointing to the Zweli Mkhize example. And he says under oath that he placed.
Mr. Mpofu, I'm very mindful of time. My question is a simple one. Are we placing more emphasis on form over substance? Regardless of what the president may have said, the president may have used the words leave of absence. Are we here in this courtroom now, and we have to distill this matter, are we placing emphasis on form over substance? If we have to say leave of absence is this, it should have been suspension, or if the word suspension had been used, then some arguments would not have been advanced today.
No, we're not, Justice Teron. Firstly, because I've answered you to say that some of those arguments apply to both. So why would it be form over substance? And I'm saying the one argument which would not be competent, which I concede would not be competent, is the one about the imposition. I'm isolating it to that, but I'm not, that doesn't mean all the other...
Would the president, or does the president have the power to suspend a minister?
No.
And what do you advance as authority for that submission?
Because it goes back to where we started. That power can only, since we all agree, all of us in the room agree that there's no express power. That can only be found on implied powers. Okay? So there are two reasons. When the Constitution wants to, when the Constitution wants to afford the president the power of suspension, it says so. It says so in section 177(3), I think. Yes. So section 177(3) says the president, on the advice of the JSC, may suspend a judge who is the subject of a procedure in terms of subsection 1. So that's the power to suspend. It also says so in section 194(3)(a). Section 194(3)(a) says the president may suspend a person from office at any time after the start of the proceedings of a committee of the National Assembly for the removal of that person. That's to do with Chapter 9 institutions. So we don't have to be scratching to find a power to suspend where it does not exist. So if the constitutional drafters wanted to grant the president the power to suspend ministers, it would have said so, as it has done in 177 and in 194. Why is that so? It is because, Justice Teron, let's take the 194(3)(a) situation. In both situations, that suspension is pending an inquiry. Right? So this is Amabungane and Nwabe now, but from the flip side. Why is that suspension pending an inquiry? Because when you are impeaching a Chapter 9 institution holder or a judge, there has to be an inquiry. But when you are removing a minister, there is no need, it is not necessary to have an inquiry. So you can't say, I am suspending you pending an unnecessary inquiry. In the other two examples, you do so, and that is why this court, per JAFTA, in EFF2, made the clear distinction between a motion of no confidence, for example, and impeachment. And it said when it's an impeachment, because of its punitive characteristics, you have to have an inquiry. But if you are going to be removed as a result of a motion of no confidence, you don't need any inquiry, because that one is a no-fault removal, if you like.
Yes, I was listening quite carefully to your interaction with my sister Justice Chitri when she referred you to EFF1,
Yeah.
and you accepted as what is stated there that where reliance is placed on Section 83 to establish exclusive jurisdiction, the exclusive jurisdiction of this court, it has to be coupled with another express obligation on the part of the
Yeah.
president. And if I understood you correctly, and please correct me if I'm wrong, you said the obligation that it's coupled with is the obligation on the president to exercise his conscience properly and not to favor his friends. Did I understand you correctly when you said
That's one
that's
of the obligations.
Where in the Constitution now do we find that obligation?
Okay. We find that you'll find it in Schedule 2. Section 87 of the Constitution says that before you can be a president, you must take an oath of office. Okay?
I ask you to make your best point now, Mr. Mpofu.
And then in that Schedule 2 oath, one of the things it says, and anyway, Justice Mogoeng made a point about this in FF1, that the president is the only person in this country.
Are you referring to the minority judgment there?
No.
Which one?
Justice Mogoeng, there was only one judgment.
No,
Yeah,
F1.
it was
The M.
a unanimous judgment. There was no minority. So he made the point that the president is the only person who is required to take the oath in front of all of us. And when he was explaining. So
Saying the obligation that the applicants are relying upon is found in the oath of office.
yes, and this is the one.
Not in any section of the Constitution.
Sorry, I don't understand that. The oath is part of the Constitution. It comes from Section 87. Let's go to
There's no
Section 87.
specific obligation.
Yeah, Section 87. Okay, Section 87 of the Constitution of South Africa. Which is also in Chapter 5.
Looking for a specific obligation,
Yes.
Mr. Mpofu.
Okay, I won't even preface. I will always discharge my duties with all my strengths and talents to the best of my knowledge and ability, and true to the dictates of my conscience. That's what, when I refer to the conscience, I was referring to this, okay? Dictates of my conscience. What does that mean? It means I'm not going to say because it is this one or that one, I'm going to be biased in their favor.
Define the obligation for me, please, Mr. Mpofu.
Act according to the dictates of your conscience is an obligation found in this book. Yes, it is.
Finish my question.
For
please.
that,
Let me finish my question, please.
for that leg, yeah.
Is that the express obligation that the applicants then are relying on? The express obligation that has to be coupled with Section 83. I'm just trying to understand the
It's
argument.
one of them.
Which is the other?
I said, the other one, I made the example to Justice Chikri, I traced it to Section 98 And I said that once you have decided to appoint an acting minister, once you have exercised that choice, then you have an obligation to ensure that it's a member of the cabinet that is appointed. That's a duty that only one person can.
Is it an obligation or a jurisdictional fact that must exist?
Well, an obligation can be a jurisdictional fact. It's not one or the other. The fact that something
Talking about
is
exclusive jurisdiction.
yes,
Obligations in relation to exclusive jurisdiction.
yes.
Because let me
Sorry.
finish my question, please. If it's a jurisdictional fact, then that doesn't go to exclusive jurisdiction.
Why? Why? If you say, for you as the president to let's say to appoint a director of public prosecutions, that person must have an LLB. That's a jurisdictional fact.
Let me try and make it simpler. In order for this court to have jurisdiction, and where reliance is placed on Section 83, it must be coupled with another express obligation of the president,
Yeah.
not a jurisdictional fact that must exist before the powers in 83 can be used.
No, that's not the law says it must be coupled with another duty, which is president specific and agent specific. And I've just given you two. One,
I've heard you, Mr. Mpuku.
yes.
Let's move on.
Yes, okay.
Now, let's go to direct access
Yes.
and urgency.
Agent.
If I understand the applicants, they rely primarily on costs and on expenditure in relation to why direct access to this court is justified. Now, this is my question. If I didn't understand,
No, you
correct, you'll correct me. Does the possible expenditure to be incurred as a result of the decisions of the president which are being impugned meet the standard of exceptional circumstances that this court has held necessary for direct access to be granted?
No, not on its own, obviously. That's not what we are pleading. We are saying that the matter is self-evidently urgent, and nobody seems to have a problem with that. We are saying on top of that, this is a matter of the utmost public importance. I don't think I need to motivate that. And we're saying that the cluster of these decisions is such that they are about to be implemented in 2 days' time. At least the one decision of the appointment of the so-called acting minister. And the other decision, which is the judicial commission, which we say is illegal, is already, I think it has already started. There was a press conference yesterday. So so it's not just a question of cost, in that sense. It's a question of saying, is it in the interest of anybody that billions and billions must be spent in what might then be found in 2 or 3 years' time to have been an illegality? Obviously not. Is it in the interest of the country or anybody that there should be an acting minister that we might find in 3 years' time was not properly appointed? Obviously not. And that's why it's urgent, because the implementation in the one case has already started, in the other cases in 48 hours.
In relation to the applicant's claim for direct access, could the applicants have approached the High Court for interim relief in respect of the appointment of the acting minister, or in respect of the commission not starting its work immediately?
No, because the issue about I'm not sure whether we're talking about exclusive jurisdiction or direct access. As far as direct,
Let me make it clear.
yeah,
I'm dealing now with the claim for direct access.
yes, okay.
On the basis that there's no exclusive
Yes,
jurisdiction.
yes.
I'm dealing with the alternative
Yes,
claims
alternative, yeah.
that have been advanced by the applicants
Yes.
for them to approach this.
Yes. Well, then the question that doesn't make sense because whenever you apply for direct access, you can. It doesn't mean you can't because it's not exclusive jurisdiction. So every time you apply for direct access, every time,
Mr. Mpofu,
yes, just.
I'll request that you at least answer the question.
Yes.
If you don't understand, ask it to be understood.
No, I
But don't
understand.
say the question
Okay.
doesn't make sense.
No. I don't mean it in a negative sense. I said that I'm the stupid one here. Yeah. So I'm saying it doesn't make sense to me. Yeah. Because my understanding, Justice Teron, if you took it differently, I'm saying that every time, when you ask for direct access, it does not mean you can't go to the High Court. Because that's a question of exclusive jurisdiction. It means you can go to the High Court, but you are asking this court for direct access for the reasons that we've gone through. So the question that says...
My question is, Mr. Mpofu, why could the applicants not have gone to the High Court?
Okay.
Why could they not have got relief in respect of interim relief in respect of the appointment of an acting minister and the start of the Judicial Commission?
Yes. Okay. Now I understand the question. Because, one, the matter is of the utmost urgency. Two, it is a matter of public importance. Three, it raises important and novel constitutional questions which would inevitably end up in this court. Now, whether we want to wait for that inevitability in 4 or 5 years' time, or we want to do it now, and four, the matter, and this is common cause, does not involve disputes of fact. So all the parties are clear.
Can you refer me to the papers where the applicants deal with that?
Yes.
Where the applicants say that why, in respect of the claim
Yes.
of direct access, why they can't approach the High Court?
Yes,
Really?
you'll find that on page, and by the way, in the respondents' answering affidavit, there's no response to this. You'll find it on page, I'm looking at the answering affidavit. 9, thank you. Is it 9? I'm just relying on my genius. You find it from page 10, paragraph 15. And we've put 4 things there. We say, alternatively, and in the unlikely event of this court finding that its exclusive jurisdiction is not triggered, then the applicants will apply for direct access upon the following grounds and exceptional circumstances. 1, the matter concerns an urgent matter of the utmost public importance. I've already said that. We say the court may take judicial notice of the nationwide peaceful demonstrations concerning the Mkhwanazi revelations. The first respondent himself has repeatedly affirmed the urgency of the matter. 2, we say the matter concerns crisp constitutional issues, that's what I just said, with no need for adjudication of factual disputes. As demonstrated below, the prospects of success are overwhelming. 3, we say the very nature of the matter is such that no useful purpose will be served by taking the matter to the lower courts, which is allowed, as I explained earlier, before its inevitable referral to this court. The continuing depletion of taxpayers' money is also of relevance. And 4, we say in the totality of the circumstances, the pleaded herein, and then that obviously deals with the other facts, it is in the interest of justice that the applicants be granted direct access. In other words,
What do you say about this court's decisions in Zondi, the Tiki Dry, a number of others where this court has said that it's indirect access matters, the views of other courts are especially important?
yes,
And while we might be dealing with an important constitutional matter, that may actually sway the scales in that important matter first being considered by the High Court and perhaps the HCA for this court as to sit as a final arbiter. So the constitutional importance of the matter may actually work against the applicants, and I don't see that being dealt with in the papers.
Well, it's dealt with in the 15.3. Let me repeat again. We accept that the matter, as I said earlier to Justice, there's nothing stopping that's direct access by implication means that the matter can go to the High Court. But we say that...
For you, just to preface it, it's on the applicant to show why it should be decided by this.
Yes. Why? Is because if we did that and waited for the matter, what we call the inevitable referral to this court, as I say in 3, I'm just guessing, 3 or 4 years' time. If we waited for that inevitable arrival of this matter to this court, by then there would be no country left in the sense that you would have had an illegal...
Is that dealt with on the papers?
Yes, Justice. When we say the very nature of the matter, then let me pause there and tell you what the very nature of the matter is.
No, I think
Well,
all judges
okay.
understand the nature of
Yeah,
the matter.
that's
It wasn't clear to us there'll be no country left as the submission that you made.
Yes. So the nature of the matter, the nature of the revelations, the nature of what we're dealing with here is such that, so when I say the nature, I don't have now in this and then say that nature is ABCD. That nature is in the founding affidavit as it is. So when I'm dealing with direct access, I'm dealing with someone who has read the full affidavit, who knows that we're dealing with implied powers that may not exist. We're dealing with 3 acting ministers and all that. We're dealing with a judiciary that is investigating, that is being investigated by a member of the judiciary. We're dealing with the possible usurpation of JSC powers and all those things. That's what we mean by the nature of the matter.
I have 2 more questions, Mr. Mpofu. The one relates to separation of powers.
Yes.
We look at Section 85.
Yes, I have.
Section 85 vests executive authority of the Republic with the President.
Correct.
Now, would it not imperil the separation of powers if this court was to interfere with the President's exercise of his authority?
Yeah. No, it wouldn't. It wouldn't, Justice Teron, because all the cases, including, all the cases against the President that were ever brought to this court have made that point, that the general rule is separation of powers, but the exception to that general rule is the standard of rationality. That's right. So the fact that the President can, we're not in England where the Queen can do whatever they want. Here we have a constitution, so the President can do whatever he wants, but it must be rational. And who are the determinants of rationality? Judges. So the only place, once you feel that the President has done anything that's irrational, there's only one place where you can go to. It's a court of law. If that court of law is going to say, well, go back to the President, well, then we'll have no country again.
Mr. Mpofu, if the court is not with you on the merits, what are your submissions about costs?
The 2 applicants, at least, well, in short, BioWatch applies.
Now, the applicants, and I think, have made numerous allegations that don't directly relate to the merits in this matter. They refer to the President protecting Minister Mchunu because he's a political ally. They refer to Phala. They refer to State Capture Commission, which don't directly relate to the legal questions in this matter.
In what ways, Justice?
And if they don't directly relate to the legal questions, is the applicant's primary goal political? And should they be spared from costs?
Okay, first let's start with the first leg. I can't fathom why the allegations, which are not denied, by the way, about what we call the factional or political affinities or the historical relationship between the president and Minister Mchunu. Everybody knows that they were the two top of the ticket in the so-called CR17 matter that has come to this court before. So I'm sure this court is familiar with it. Everybody also knows the Pala matter has also come to this court. So everyone knows that that matter is in the public domain, even if it had not come to this court. So if one makes, you can't just, if you wanted to impose costs on the applicant, you would do so if they come and said, no, the president is just biased, without substantiating. But when they substantiate, and you want to punish them for substantiating why they're saying the president is the reason why he is treating Minister Mchunu differently from Deputy Minister Whitfield, is because the one is his political ally, and explain why. If you're going to be punished for that, for substantiating, that it might not be so is a different matter. But to be prohibited by a court from saying it, then again we'll have no country. Because it would mean nobody must say what is, must even allege, let alone anything about this president. They mustn't allege it, let alone having to establish it. Well, that's fine then. Then in that case, yes, the applicants should be punished for expressing a view about why they are saying the president is biased in this particular case. Then they can be punished or face the. Yes. Oh, sorry. And in any event, just it's interesting, but the the president is not asking for costs, let alone punitive costs that are now being suggested. And I'm sure it's because the president understands. In fact, the president has dealt with those issues with the Pala and the.
Mr.
Sorry.
Pofu, nothing has been suggested. Questions are being posed,
Yes,
on
okay,
which we
yes.
would like to hear your view.
Yes. No, I'm saying.
Just
yeah.
to make that clear.
Yes.
But
On those
you've answered my question.
Yes.
Thank
Those-
you very much, Mr. Mpofu.
It's a pleasure.
Justice Mhlantla.
Mr. Mpofu,
Yes, Justice Matop.
well, it is common cause that this matter is urgent. All the parties agree.
I would have thought so, Justice Matop.
And if it is urgent, it is also common cause that for you to come home, you have to establish whether you have exclusive jurisdiction or direct access.
Yes.
You may be weak on exclusive jurisdiction, but you'd come home on direct access.
That's,
Speaking for myself,
yes.
I think you do come home on direct access
Thank you, Justice Matop.
for the reason that you've expressed.
Thank you, Justice.
I'm just saying it.
Yes.
But my mind is open, I'm keeping an open mind. Your colleagues, prima facie, your colleagues may convince me otherwise.
As God please.
So then there are three issues.
Yes.
It's the issue of
Leave of absence.
whether the president has implied power or not. And you're saying Masetle is against us.
Yes.
Or it's against the respondents.
Yes.
And if it's correct, then the appointments, the second appointment and the third appointment fails.
Absolutely.
In other words, if you don't come home on the first point,
Yes.
is it correct to say the second and the third point you fail?
No, no. It's the other way around, Justice Matopo.
No, but if you,
Thanks for
let me put it this way.
Okay.
If we find that the president has the implied power and the necessity that you said does not exist,
Does exist.
right? Then he would have had the power to make the appointment.
Yes, no, yes, Justice Matopo, thank you for that question. I really appreciate it because I think it gives me an opportunity to explain my case properly. Yes, Justice Matopo, you're right. In fact, the analogy you make works in the one way, but not the other. Let me explain. If we are correct that the president does not have implied power to act, in other words, he acted ultra vires, then there's no need for this court to then examine whether that leave of absence was rational or not, because it's already ultra vires.
That's fine.
I agree, yes. So, however, Justice, the opposite does not hold true. So if the court is against us on implied power, then it means the court has to then look into the question of rationality. In other words, let's assume the president does have the power, but on these facts, did he exercise it rationally? And the answer, the short answer we give is that since there is, since he was exercising...
Let's because we've had this long debate.
Yes, we have. Yeah, thank you, Justice.
If he has the power, right? Let's put it this way. You are saying if he doesn't have the power,
that's it.
That's the end of...
Yes.
It's like it's
end of go to rationality.
Falls down. But if he has the implied power, you go to rationality.
Absolutely.
And if you find that the actions or the decisions were rational, you out as well.
I'm out.
So
completely.
If you're out on everything.
No.
That's where I went to.
No, okay.
So how can you be in when you're out on the main one?
Okay, because Justice Matopo, I'm not. It's the president of this country. It's not me who said he must make 3 decisions. So he made the 3 decisions, and we're assailing them. That's why you have prayer 3.1, 3.2, and 3.3. So we assail them in their individual right. In other words, to answer your question in shorthand, Justice Matopo, it is possible, theoretically, it is possible.
No, let's be practical. Let's not be theoretical. Is it
Shouldn't be fine. Thank you. Checks on it.
On these pleadings, on the rest of the motion, it's possible for the court to say, okay, we need 2.1 but not 2.2, 2.2 but not 2.3. So it's not like those cases where if you don't come right on 2.1, you're out. And the reason for that is because, for example, while the...
Your mic is not on, Mr. M. No power.
I thought it was still not working.
Not working.
Thank you, Justice. No, you're right. I thought everything was out. Okay, but, it's back. So I'm saying, Justice Matopo, pardon? Mine is on, yes. I'm saying that the Judicial Commission decision, for example, can be viewed on its own, in its own, it can be impugned, let me put it that way, on its own. In other words, you could say the president has the power. Yeah, has the power, and he exercised it rationally. Yes. On leave of absence, yeah. Then 3.1 is gone. Yes. Yeah. Now I'm saying if you do that, then the Prof. Cachalia decision can be viewed in its own right. So you can say that and still say, but the president did not have the power in terms of Section 98 and 93, the discussion I had with Justice Chikwi, to appoint Professor Cachalia. And, thank you, yes. And you can also say the Madlanga Commission. Yeah, thank you, thank you, thank you very much. Thank you. Yes. 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 Yes.
For me, it seems like you place more emphasis on the president, because I will appoint, I decided to appoint, did I read it correctly?
No, you read me incorrectly. Because that's what Justice Chikwi was accusing me of that as well. And then I took her to page 91 to show that it's...
So it's not?
No, it's not. It's not just the announcement. It's what he says in the answering affidavit, which is the same thing.
So are you saying constitutionally, the president, okay, let's say it's common cause that the president constitutionally, in terms of Section 91(3)(c),
See, yes,
can appoint an outsider
as a minister,
as a minister?
100%.
Right. Now, if we take the facts of this case, if correctly the president has exercised the powers which you are disputing, the implied powers to put Minister Mchunu on leave of absence,
Yes,
he's off. And the president exercises his power in terms of 91(3)(c) to appoint Professor Cachalia. And once he's appointed, he becomes a cabinet minister or a cabinet member,
yes,
right? Professor Cachalia will not assume or take office until he has been sworn in,
sure.
right? We agreed.
We agree.
And according to the president, he will only take office on the 1st of August.
Agreed.
We agreed.
Agreed.
So what will start is the announcement.
The
Right?
appointment.
Sorry, it's the announcement, followed by the appointment in terms of 91, 93, what is the?
91(3)(c).
91(3)(c). No, I meant 90.
8.
The first section where it's got the right to appoint and dismiss.
That's 92(1).
92(1).
Sorry, 91(2). Sorry.
And yeah,
91.
he has to make that appointment, right? Once he's appointed, then the president will look, where do I place you? Where do I place you? And he looked in the position where Minister Mchunu has been put on leave of absence. There is a vacancy, right? And if the president says, because there is a vacancy, you are now a full-time minister, I can, to use the political word, I can deploy you,
Redeploy.
yeah, or redeploy you to the position of Minister Mchunu, because he's absent from work, unable to
Is absent from
yeah.
office. Yeah.
right? Why is that wrong?
No, it's not wrong. It's just not what happened here. The president should have come to you before what you are saying, there's nothing wrong with it, but it is most decidedly not what was done. That would be nice, and it would be constitutional. But what you cannot do, that advice, you can't have it after the fact. That's what's called ex post facto rationalization. What the president did, Justice Matopo, did in actual fact, was to say, I am appointing Professor Cachalia as an acting minister. And he says that not just in the announcement, as I've explained to Justice Chikri, he even says it in his answering affidavit. So he's clear about what capacity he was appointing Professor Cachalia into, acting minister. He cannot do such a thing under Section 91(3)(c), because Section 91(3)(c) is to appoint ministers per se from the general public or from the National Assembly. Where he can appoint him as an acting minister is under Section 98. But the problem he has there is Section 98 says, for me to make you an acting minister, you must already be a cabinet minister.
But you would be a cabinet minister in terms of 91(3). But you said it's. I think where I have a difference with you
Yes.
is you seem to be putting more emphasis on the appointment itself,
Yes, but
on the announcement. Sorry.
no.
Yeah, you seem to be putting emphasis on the announcement. Or let me put it this way.
Page 91, paragraph 57 of the I think it's volume 1 or volume A, I think that's what it's called.
And that would be what? Under which heading? Just
That's the first, page 91, paginated page 91, Justice Mato.
I need to get there. This is a very important point for me.
It is. No, it is indeed.
Yeah, what paragraph is that?
57, Justice. I've elected to appoint an acting minister of police from outside cabinet, as I'm entitled to do in terms of Section 91(3)(c). That's a misstatement of the law. Section 91(3)(c) does not entitle him to elect to appoint an acting minister of police. The section which he was obviously oblivious of, which entitles him to appoint an acting minister, is Section 98.
But Mr. Mpofu, I think we're quibbling with words. There is no way that the president could have appointed an acting minister from outside.
Well, that's what he says, under oath. So we must tell him he's lying. There's no way, but there's a way, because that's exactly what he did.
No, I can't take it any further.
Well, we wouldn't be here, Justice Matopo. The only reason we're here is because the President Ramaphosa says, I swear before God that I have elected to appoint an acting minister of police from outside the cabinet.
But is this not the debate that you have with my sister, Teron, that we put in form over substance?
Well, maybe. It looks like it is. But the point is...
But it looks more like it looks more like it, not any other way.
But no, Justice Matopo, with the greatest respect, what you are doing is actually doing the right thing, that no president in his right mind could appoint an acting minister from outside the cabinet in terms of 93(1)(c). We agree.
It is wrong.
Thank you.
Yeah.
Please. Shh. Justice Majid.
Mr. Mpofu, just exclusive jurisdiction. You rightly said that one must have regard to the pleadings to determine exclusive jurisdiction. Can I take you to paragraphs 13 and 14 of the founding affidavits, pages 9 and
1.3 and 1.4, yes. I'm there, Justice.
Yes. Now, you mentioned section 167(4) and you mentioned Nkandla and my vote count, but you don't mention section 83 there. What must we make of that?
No, but Justice Majid, with the greatest respect, yeah. The pleadings, when you say the pleadings, you mean the pleadings as a whole, not one paragraph. So section 83 if you go to,
Can I just stop?
yes,
Page 9C, exclusive jurisdiction and direct access.
yeah,
Then you deal at 13 and 14 with exclusive jurisdiction. Then 15, you.
yes. No, there's nothing wrong with that just sheet. All I'm saying is that when you look at pleadings, you look at the pleadings as a whole. So if you go to paragraph 39, you'll see where, 40 rather, yeah, where we outline the requirements of section 83, okay? And if you go to, where it says the president must uphold, defend, and respect the constitution as supreme law or whatever, then you'll also find in...
Mr. Mpofu, sorry to interrupt you, but I mean, here you're dealing with the merits of the case. You've dealt with exclusive jurisdiction and direct access. These you quote in the context of these three issues that we did.
Yes, but that's what it means when it says the pleadings. It means the pleadings, including the merits. The pleadings
Is that your
as
answer?
they stand.
Is that your answer?
Yes. In Gaba, it says to find
Can I
jurisdiction.
go to the second aspect? I'm satisfied, thank you.
Thank you.
There was something that struck me in this case about the Commission of Inquiry.
Right.
And you mentioned earlier, the entire judiciary is tainted by these allegations.
The entire?
Judiciary.
Yes.
You even spelled it out, judiciary,
Yeah.
which includes the entire judges of the country.
That's what it says.
That's what you said.
No, that's what Mkhwanazi says.
Yeah, that's what he says. Yeah, you say, therefore, Justice Madlanga is disqualified from hearing,
No.
from sitting in the Judicial Commission because he's a judge. You
It's
said
got
it
no-
should have been a commission, and then it would have other problems.
No. It's got nothing to do with Justice Matlanga. It says there is a species of Nemo Iudex called institutional
I
bias.
understand that. Yes.
So it's the institution, not Justice Matlanga.
I understand that. That's why I'm
That
saying,
is standing in the dock.
yeah. The entire judiciary is
in the dock.
disqualified as an institution.
Is in the dock, yes.
But why is the case in this court before the judges? How are we qualified to hear this case and he's disqualified as a judge of the institution to? I hope I'm not sounding facetious.
No,
But it just
well,
occurred to me,
I
it's
want
a
to answer
different
that
thing,
question.
because we are asked to decide this challenge, which goes to the heart of the establishment of the commission. So how are we qualified, but another judge, a member of the institution, is disqualified? Qua judge.
No, but Justice Machit, you are qualified because you swore when you were being admitted as a judge to apply the Constitution of the Republic of South Africa. And we are saying here that in the leave of absence decision, the Republic of South Africa, the Constitution of the Republic of South Africa was breached. That's got nothing to do with Justice Matlanga or anybody. We say the appointment of Acting Minister Cachalia was unconstitutional and all the things that we say, that has got nothing to do with this. And we say, in relation to the commission, that the judiciary is conflicted. I'm putting it colloquially. Now, every time, in fact, when you do a recusal, you do it to the judge. So the judge can say, well, why are you asking me? What is that? Because the judge is compelled by his or her oath of office, even when the recusal is against him or her, to adjudicate it. So,
I don't understand it. I mean, you're talking about an institution, the judiciary, but I hear you. I hear your answer. Now, just lastly, you say, and I'm dealing with a leave of absence, because as you say, but for the leave of absence, we wouldn't have had an appointment of the professor. Now, you say there are only two possibilities in the exercise of his presidential prerogative. The president can only appoint and dismiss. There's nothing in between. There's no room for suspension or placing on leave, as he calls it.
Well, I say two things. I say, to the extent that leave of absence, there's definitely no power for the reasons that I've explained, because you can't place someone on leave of absence. But if you take Justice Theron's formulation to say, okay, well, let's arose by any name. Let's say it was a suspension. Then I've answered that. I referred the court to 177 to...
Can I ask you about 177 then?
Yeah.
Because we've heard that 177 deals with a judge being removed from office, and 194 deals with head
of Chapter 9.
of Chapter 9 institutions. Is the word suspension there not deliberately used because there are other actors at play here? It's not just the president who takes a decision, I'm going to appoint or dismiss a minister, but here we have the National Assembly that must, through a vote,
Sorry, Justice.
oh, sure, must through a vote to remove them, a judge or a Chapter 9 institution
Right.
holder. Is that not the reason why the president is expressly given the power to suspend there? And therefore, there is no such express provision here, because it's his prerogative, it's his discretion, it's his power. He's empowered to do so without any outside actors like the National Assembly.
No, firstly, because even in the other, if you look at 194.3, 194.3A is also a prerogative, so that's not a reason.
There, the National Assembly plays a role. Do you accept that?
No, of course, that's for a different reason. That's because it's a punitive removal. And because it's a punitive removal, this court said in AFF 2, because it's a punitive removal, you must have a process, a disciplinary process, for lack of a better word. You must. It's necessary. That's where the necessity test comes in. There, you said, Justice Machiti Mngwabe, that the test is necessity. In those examples that are giving me, it is necessary because there has to be an inquiry. And that's why Justice Jafta and Justice Zondo, for that matter, even in the dissent in AFF 2, made the distinction between an impeachment and a motion of no confidence. The one requires an inquiry because it is punitive, but the other one, because it's a prerogative, in this case, it's a prerogative of Parliament, let's say, to remove you in a motion of no confidence. You don't need an inquiry, so it's not necessary.
And lastly, just on this, on the same topic, the Constitution says we must have regard to international law. It's noticeable, and within the limited time available, it's noticeable that of countries with constitutions more or less resembling our own, for here I'm just leaving out the US for now, but Germany, India, Namibia, and Canada have no express provisions to remove, to suspend ministers or cabinet secretaries. The only one that does have, and through an act of parliament, is Kenya. Is there anything that we must make of that? In other words, in those jurisdictions, it's an implied ancillary power of the type encapsulated in Amabungane and the Madlanga J judgment.
No, well, the first part is correct, the second part is incorrect. It doesn't follow that because it's not mentioned in other constitution, it means it's an implied power. It means it's non-existent. So yes, it's true that in fact, to be fair, even in the so-called common law countries, because this thing comes from Britain in the end, there, because the two things, there's a culture of people just resigning when these kinds of allegations are made. We don't have that culture. But there is the Queen and the Prime Minister. It's said in typical British fashion, it's in the gift of the Prime Minister to have you as a member of the cabinet. But here, the point I was simply making, Justice, was that you can't imply, if you use the test that you gave in Mwabe and the test that's given in Amabungane, and for that matter, the test given in Masetla. You can't imply that the power to place on special leave, assume there's such a thing, the power to place on special leave is so connected as the breaking of the egg when you are making the omelette in the example that Hoekstra makes. In other words, you can't make the omelette without breaking the egg. So you can't say you can't dismiss without leave of absence. That would be far-fetched.
That means that if a minister is accused in the public domain of something that's less serious than would have warranted removal, the president must then dismiss. Yeah, no, there's no in between. There's only appointment and dismissal.
Yeah, can dismiss or retain. There's nothing wrong with him retaining.
There's no via media.
No, there can't be. Only via media, it can't be in our heads. The via media must come from the law.
Yeah,
That's what Fetcher says.
Thank you.
So
Mr.
Justice Machel, sorry to... It's an or not granting. If they go to 150, this, while you're, let me explain to you why the
I've got it.
president
Giving a reference.
yes, 158.
Okay.
That if a minister requests to be placed on special leave, the president has the power to grant that.
No, that's not what I'm saying. I'm saying,
No,
sorry.
so there's neither the power to place on special leave nor the power to grant special leave on request.
Well, Justice Rogers, I'm not concerned. If there is a power to place, for example, for argument's sake, and I'm going to answer your question directly. I'm saying even if there was a power to grant, which I don't concede, there's certainly no power to place forcefully. Now,
So if there's a, I know you concede neither, but if there were a power to at least grant,
yes,
then that would have to be an implied power, because it's not expressly conceded.
certainly.
So if a cabinet minister gets a cancer diagnosis and wants to take 6 months off for treatment, requests special leave, you say the president's only permissible response is to dismiss her from the cabinet.
No, that's not what I'm saying.
Well, if she says, I want 6 months special leave for medical reasons, you say the president doesn't have the implied power to grant that.
No, I say he doesn't. But I'm saying something more, Justice.
So if he doesn't have the implied power to grant, what can he do if the minister is going to be off for 6 months for medical reasons?
What can he do? Yes. In the best interest of the country, what he can do is to remove that minister. And when the minister, assign those powers to somebody else.
So the answer to my question was his only option would be to dismiss her.
Well, you see...
Well, you can call it dismissal,
removal, withdrawal of the powers, yes.
A cabinet minister.
Yes, but I want to qualify my answer if I may.
My brother Majid touched on questions in other jurisdictions, also in the limited time I've had available, in jurisdictions which come from a similar parliamentary culture to ours in the way cabinets are composed, in the discretion of a president or a prime minister.
Yes.
Sometimes I appreciate nominally through the crown.
At the pleasure of the president.
The idea of ministers being on special leave is of frequent occurrence. And it can include for personal reasons, including medical. In Australia, there have been several instances where it is pending a commission of inquiry. So it, as an element of prerogative, it doesn't seem alien.
No.
And to the extent that our Constitution expresses the idea of appointing and removing cabinet ministers, it seems to be capturing, and I think your submissions mentioned the prerogative, it's basically expressing in words the prerogative of the head of the government to compose his or her cabinet.
Yes.
And if other countries allow, who live under a similar regime, have procedures for granting leave of special absence to cabinet ministers, why would it not be regarded as suitable here? Is it consistent with our constitution, for example, to say that the only answer to an unwell cabinet minister is to remove them from the cabinet?
Well, the first answer is that we can't do it just because it's done in other countries. That's why we have our own constitution. Otherwise, we should just go according to the constitutions of the world. The second answer is that, as I've said, Justice Rogers, our case is that even if, and therefore the debate then will not go anywhere, because we make that, let's call it half concession, to say even if the power to grant, as was exercised in the Mkhize example, exists, for argument's sake, we say even if it does, certainly the power to place somebody, to impose leave of absence to someone who has not asked for it, which is what happened in this particular case, does not exist.
I don't wish to debate it further, but the only relevance for us would be this, that if we find it incomprehensible that the President would not have a power to grant special leave in circumstances that he considered appropriate upon request by a minister, it would immediately involve finding that there is at least that implied power by the President to grant it,
yes,
even though it's not expressed. And it might then not be a very far remove to say, in other circumstances that he considers appropriate, even when the minister does not request it, he can bring about the same result. That's significance. I appreciate you've got stage 1 and stage 2, and if you fail on those 2 stages, you've still got the further argument. You say that it was in any event irrational, even if he had the power.
Yes. Thank you, Justice Rogers. If I may just, as I did with Justice Colapen, again, the one thing that I must not leave this court with anybody having an impression that I am saying is that the President can only fire or hire. I accept, as I must, that there must be other things in between which, if they are reasonably necessary, would be implied, such as the one you are postulating, such as the one I was postulating of saying, if he says, okay, I'm removing you, but I want you to spend another month to finish the school that you're building or whatever. Those things are clearly would fit within the doctrine of necessity. All I'm saying is that in this case, the doctrine of necessity has not been satisfied because